Michigan versus Danielle Rollings, 232230. And Detective, your name for the record, please.
Detective Chelsea Haskins.
All right, please raise your right hand. You solemnly swear from the testimony about to give this man be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. And you may proceed on the warrant.
On October 11th, 2023 at 12:35 a.m. While on patrol in the city of Wyandotte, Officer Harris observed a 2005 Grand Marquis tan in color. The vehicle had a cracked windshield and the passenger side rear brake light was damaged, exposing the white light. Officer Harris initiated a traffic stop on Fort Street near Clark Street. Per a lien search, the registered owner of the vehicle, Danielle Rawlings, had a suspended driver's license. The driver was identified as Rawlings. Officer Harris observed Rawlings' two small children in the back seat of the vehicle. During his investigation, Officer Harris could smell the odor of intoxicants emitting from Rawlings. Rawlings admitted to consuming 2 vodka drinks. Rawlings was asked to step out of the vehicle to perform field sobriety tests. Rawlings only agreed to finish one of the tests, which indicated she was intoxicated. Rawlings agreed to a PPT test, which indicated she had a BAC of a 0.23. Rawlings was advised she was under arrest. While searching her purse, Officer Cox located 6 amphetamine pills. A MAPS report showed Rawlings does not have a valid prescription for these Schedule II narcotics. A breath test was completed at the Wyandotte Police Department, where Rawlings produced a sample of 0.2 BAC. This is Rawlings' second OWI. The first occurred in Flat Rock in 2021.
All right, upon examination, excuse me, of the complaining witness. I find the offenses charged were committed. There's probable cause to believe the defendant committed those offenses. And we're going to go off the record. We're just waiting for the attorney to log in.
Hello, hello. Hello, hello.
So we're going on the record in the matter of the state of Michigan versus Danielle Rawlings, 232230. And appearance, counsel.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands mute.
Okay. And good morning. And ma'am, your name for the record, please.
Danielle Rawlings.
Okay. And counsel, I'm sorry, you said as to the formal as to the arraignment, you're going to waive the formal reading?
Yes, Your Honor.
Okay. All right, the court will waive the formal reading. Ma'am, you have the following rights. You have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Correct.
You also have the right to be presumed innocent, so if we've been guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
I understand.
All right, the court's going to enter a plea of not guilty on your behalf. Schedule this matter for a probable cause conference on October 19th at 8:45 a.m. And counsel as to bond.
Apologies, Judge. Your Honor, I've had an opportunity. I reviewed the matter with my client. She's apologetic for the scenario she finds herself in, but indicates she will comply with any terms, conditions of probation. So we're respectfully requesting, as to bond. We're really requesting leniency when determining the appropriate bond. Thank you, Judge.
Okay, thank you. And ma'am, you were just on probation in the 33rd District Court, correct?
Yes.
And you don't have a valid driver's license, is that also correct?
I didn't know it was suspended, but I did know that I was not keeping up with my probation. Yes.
I'm sorry, you didn't know you were suspended, but you what?
Can I take this off for this?
Yeah.
I'm sorry, I have COVID. It's hard to deal with. I didn't know that my driver's license was suspended. I did know I had a problem with alcohol, and I was kind of scared to show up to my drug test, and it ended up going behind. I got nervous to turn myself in, but I did let him know I'm willing to do anything just to completely be done with the alcohol. I realize I have a problem. And I've also had, yesterday I let them, give me medication to wean off. I just want to be completely done with everything so I can be better for my children, please.
So you did not successfully complete your probation in the 33rd District Court?
I did not, but I will do everything right now that I can to fix both of them. And I am on day 2 or 3 now of being on medication to completely be off alcohol. It was a dependency thing, and it developed, and I'm completely done with it. I want nothing to do with it. I just care about my kids. I'm completely ashamed that I even put my children at risk. I've always been an excellent mother. Then my mom also wrote a note to you. They were supposed to tell you. I don't know if you got it or not.
Your mom was supposed to write a note to me?
She did. The police officers asked her to write a note to you, or through the attorney, and you were supposed to receive it.
Okay, well, I can indicate that I have not received any note, whether email or otherwise. I will
They gave
check
her
the
a
file
paper
to see if there's anything. Hold on, please. I will check the file to see if there's anything in the file, but I don't see anything in the file. Detective Haskins, your name for the record again, please.
Detective Chelsea Haskins.
Do you have a note from her mom?
I do not know. I do not know that her mom submitted a note.
Okay. All right. Mr. Shenke, do you have a note from Ms. Rowling's mom?
No, Your Honor.
They asked her to
Okay,
send
Ms.
note, and
Rowling.
she
I'm sorry, what's that?
I said they had asked her yesterday to send a note and gave her something to show how to send it in, and she sent it in yesterday. She typed it in and sent it into the court, and then she came up here actually with my sister to make sure.
Okay, well, I don't know where that note went because we don't have that. So, okay, and Detective, would you like to address that?
Yes, I do have concerns about the safety of the public. This is her second OWI. She was a very high BAC. She did have her children in the car, so I'm concerned for the safety of not only her children, but the public. Also, the severity of the charges, endangering children with a high BAC OWI, as well as the felony charges for the narcotics, possession of the narcotics. I'm going to request a $25,000, 10% bond with an alcohol cover.
All right. Well, given that Ms. Rawlings was previously convicted of an operating while intoxicated or operating while impaired out of the 33rd District Court, did not successfully complete probation, in fact, has a warrant out for her arrest for her failure to comply with terms of probation, and given the alleged level in this matter, and that her minor children were in the vehicle as well. How old are those children?
Pardon me?
How old are the children that were in the vehicle?
3 and 4.
3 and 4, is that what you said?
Yes.
And so based upon that, the safety of Ms. Rawlings, the danger that Ms. Rawlings poses to herself, her children, and the public, the court does find that the recommended bond request is appropriate. $25,000, 10% bond. In the event you post bond, you're not to be released without an alcohol tether through the Wayne County Jail. You're not to possess or consume any alcohol or drugs unless prescribed. And you will also be subjected to random testing. So in the event you post bond, ma'am, you need to report to the 27th District Court Probation Department the next business day. So if you post bond on Saturday, you need to be reporting here on Monday. If you post bond on Monday, you need to be reporting here by Tuesday for that testing. Anything else?
No, Your Honor.
Thank you, Your Honor.
All right,
Thank you,
thank
Judge.
you. All right, thank you. We're going to be off the record. Okay, Mr. Lovely, are you driving?
Yes.
Okay, I need you to pull over, sir.
I actually have clients in the vehicle.
I'm sorry, I can't hear you.
Clients in the vehicle. Chauffeur.
He's chauffeuring, I think is what he's saying.
Yes. Yes, I understand that, but I'm not going to conduct this matter while you're driving. So as soon as you pull over, I can call the matter, okay?
Well, Your Honor, respectfully, I don't think, I have other matters to tend to. I don't want to, I mean, if it's a minute, if he's just gonna pull over, but it sounds like that's not what's going to be happening.
Counsel, I 100% agree with you and understand what you're saying, but I cannot call this matter with him driving.
I understand that it could be entered as a default. I mean, he's been disconnected twice. I mean, this is the time and date set for hearing. And
Understand that, but he's present. I'm not going to enter a default right now since there's been a consent. So Mr. Lovely has to pull over so we can put the consent on the record. And so Mr. Lovely, you need to pull over so we can call this matter.
All right, 1 second.
Okay, and so Mr. Lovely, are you pulled over?
No, I'm on the highway, so I have to wait a second.
No, Mr. Lovely, I can appreciate that you're working. However, this is the court date, so I'm not sure why you thought it was a good idea to drive while you're on your court date.
I understand.
Thank you. Okay, Mr. Lovely, are you pulled off to the side of the road now?
No, I still haven't had that opportunity.
I'm sorry? Sir, you can pull over to the side of the road.
On the highway.
Well, sir, what highway are you on? Mr. Lovely,
Yes.
I'm not sure if you think I don't know the highways around here, but you absolutely could have pulled over by now. So I'm about to enter a default judgment if you are not pulled over in the next 15 seconds.
I'm pulled over now.
No, you're not. You're still driving, sir.
I'm pulled over.
Now you're pulled over.
What was that?
You're pulled over now.
Yeah. Yeah, I got the clients
Okay.
to agree, so.
I'm sorry?
What was that?
What'd you say about the client?
Oh, nothing. It was kind of irrelevant, but I'm pulled over.
Okay, sir, I understand that you're working right now, but whether or not the client agreed to be pulled over at this point, the client does not overrule the court. The court ordered you to pull over 10 minutes ago.
Understood.
All right, we're going on the record in the matter of 2301987 Royal Woods Townhomes for Sherman Lovely and Javondra Johnson. And appearance, counsel?
Good morning, Your Honor. Cheryl Walkoff on behalf of the plaintiff.
And sir, your name, please?
Sherman, lovely.
All right, and so today's the date scheduled for the second hearing in this matter. And counsel, you indicated that there's a consent judgment?
Yes, Your Honor. The terms are as follows: rent to retain possession, $1,867.83. Court cost $200. The total balance is $2,067.83. The writ date is October 23rd, 2023. This is for possession only. I did explain the defendant his rights under MCR 4.201 that he's waiving his right to a trial. He does have 3 business days to ask the court to set this judgment aside. We're asking for entry of the judgment, and he has given me permission to sign on his behalf.
Okay, and Mr. Lovely, where is Ms. Johnson? Do you know?
What did you say about Miss Johnson?
Where is she?
She's not on, I mentioned it last time, but she's not on the lease.
Your Honor, if that's the case, which I will confirm, I will omit her from the judgment. I do need to confirm that.
Okay, I do recall that last time and I was thinking that was good, but it hasn't been confirmed yet?
No, it has not. I don't plan on taking a judgment against her because frankly, it's possession only. It's not really going to impact at this juncture. So we can just enter it on the record against Mr. Lovely.
Okay, so consent judgment against defendant 1 in the amount of $2,067.83. Is that what you indicated, counsel?
Yes, it is, Your Honor.
Okay. All right, so Mr. Lovely, you heard the terms of that agreement, correct?
What was that?
Mr. Lovely, you heard the terms of the agreement, is that correct?
Oh, yep, correct.
Okay. And
I will send a dismissal on the second defendant.
okay, so you heard Ms. Pierreski. Okay, so Mr. Lovely, you understand that you do have the right to have legal representation, not at the court cost, but at your own cost, or legal or low cost or no cost. Do you understand that?
Yeah.
And you are proceeding without an attorney, is that correct?
Yes.
You also understand the terms of the judgment, is that correct?
Yes.
And counsel, I'm sorry, you did indicate you went over Mr. Lovely's rights under the court rule?
I did, Your Honor, yes.
Okay. All right, and so the court will indicate that by consent, the plaintiff does have a right to recover possession of the property. The amount not due and owing for unpaid rent and other costs is $2,067.83. If that amount is not paid or defendant's time about on or before October 23rd, plaintiff applies for order evicting the defendant. Partial payment will not prevent the court from issuing an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. No money judgment will enter at the time, and the court will also grant the dismissal against defendant 2. And the court will sign that upon receipt. Anything else?
No, Your Honor, thank you.
All right, thank you. All right, thank you, Mr. Lovely. Next time, if you're in court another time, please make sure you're not driving while you are having your case heard.
No problem. What time is that on the 23rd?
Yeah,
Sir, no.
There's not a time, sir. There's not another court date. You have until the 23rd to either pay it or move out.
Oh, okay, that's fair. Okay, I thought it was a date. Okay, I understand.
Okay. All right,
No
thank you.
problem.
All right, have a good day. All right, and Ms. Lukoff, any?
Is it okay having myself here?
Yes. We're on the record. In the matter of the state of Michigan versus DeJuan Lee, 232234. And appearance, counsel?
Good afternoon, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Lee.
All right, thank you. And Detective Sergeant Grote, if you can please state your name for the record.
Detective Sergeant Ken Grote.
All right, please raise your right hand. Do you solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You may proceed on the warrant.
October 13th, 2023, approximately 5 a.m., Wyandotte officers Cox and T. Grove were dispatched to the Jimmy John's restaurant located at 3169 Biddle in the city of Wyandotte. The caller was a store employee who arrived for work and noticed an occupied running vehicle parked outside the business and had not moved. Officers arrived and located 2 males inside the vehicle passed out. Officers could smell a strong odor of alcohol coming from the officers attempted to wake both individuals, but they were unsuccessful and requested a rescue to make the location. While waiting for the rescue, Officer Cox was able to reach inside the vehicle and turn the vehicle off, and he was able to wake up the driver, later identified as Mr. Lee, for a moment, then he passed back out. Officer Cox saw a black plastic squeeze container on the center console in the cup holder next to Mr. Lee and one laying on the driver's side floorboard next to Mr. Lee's foot. Officer Cox removed the container and saw that they contained several individual baggies that contained cocaine. The Wyandotte Fire Department arrived and were able to wake up Mr. Lee and his passenger, and both were highly intoxicated. They thought they were in the city of Detroit. Both Lee and his passenger refused medical attention and signed off for treatment. Officers took Mr. Lee into custody, and at the station, they field tested positive 7 small individual cell phone baggies that field tested positive to be cocaine, and total weight was 3.6 grams.
All right, thank you. Upon examination of the complaining witness, I find the offense charge is committed, there's probable cause to believe defendant committed the offense. And sir, your name for the record, please.
Your name.
Dewan Lee.
Okay. And counsel as to the arraignment.
At this time, Judge, we are prepared to waive a formal reading. My client stands mute.
Or waive the formal reading, enter plea of not guilty on your behalf, on your client's behalf. Sir, you have the right to have an attorney. If you cannot afford to retain your own counsel, the court will appoint one to represent you. And in fact, you had an opportunity to speak to an attorney today, correct?
Yes.
Okay. And you also understand that you do have the right to have a trial by a judge or by a jury. You have the right to remain silent. Anything you say orally or in writing may be used against you in court. And you also do have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand all of your rights, sir?
Yes, ma'am.
The court has already entered a plea of not guilty on your behalf. We'll schedule this matter for a probable cause conference on October 19th at 9:50 a.m. And counsel as to bond.
Yes, Your Honor. I would like you to know that Mr. Lee currently resides in Detroit. He works as a caregiver. He's not currently on probation or parole. And after speaking with him at length this afternoon, he did assure me that he would be appearing at all future court dates. He does understand the importance of making sure that he does appear. I would just respectfully request that all that be taken into account when assessing a bond on behalf of Mr. Lee.
All right, thank you. And DiSanto Sergeant Grote as to bond.
Your Honor, Mr. Lee, he's been a model prisoner, didn't give the officers last night a hard time. He has a minimal criminal history. The reason we'll ask for a bond is he has no ties to the community. We'll ask for a $5,000 10% bond.
All right, thank you. Sir, what happened? It shows you've been charged before in matters, but it doesn't appear, it shows that you were charged in 2006 for domestic violence, but doesn't show what happened. In 2010, it shows that there was a felony assault warrant requested, but it doesn't show what happened. What happened with those matters?
I think they got dismissed or something. I really don't remember. 2000 and she said
6 and 2010.
Domestic violence
In 2006.
I've gotten, I think I got into it with my lover.
I just want to know what happened with the case.
Oh, everything was dismissed.
Okay. All right. Are you currently on probation or parole anywhere, sir?
No, ma'am.
Have you ever failed to appear in court for any reason?
Yes.
Okay, and why did you fail to appear in court?
I failed to appear in court when?
No,
I
she
don't know,
asked
you
you.
just answered that you did.
No.
She asked if you ever failed to appear.
Oh, no, ma'am. No, ma'am. I never failed to appear in court.
All right.
I didn't
Okay.
hear her.
That's okay. Given the defendant's lack of ties locally, the court's going to indicate a $5,000 10% bond to ensure Mr. Lee's appearance. In the event you post bonds, you're not to possess or consume any alcohol or drugs unless prescribed. Okay,
Okay, thank you, Your Honor.
thank you. Have a good day.